I want to talk about healthcare decision-making and the real practical impact, really what happens when you sign a healthcare surrogate designation, what happens when you sign a living will. If you don't have a healthcare surrogate designation, then you're relying on a proxy. And I hear lawyers talk about these documents, very important documents, really mostly superficially. They tell you what they do, but really what I want to do is get into the nitty-gritty of how things work in like a real-time emergency situation. But to give you a little background, I think it's important to first explain how Florida statute defines the term healthcare decision, because that's going to lead into a very important that definition is going to be very important with regard to what a healthcare surrogate or healthcare proxy can do, and making sure that your wishes as indicated in a living will and how they're executed. Okay, so Florida statute 765 has a definition for a healthcare decision. A healthcare decision is defined as the ability to provide informed consent, refusal of consent, or withdrawal of consent, including the providing or withholding of life-prolonging procedures, unless otherwise stated in the advance directive. So let me pause right there in this definition. So if you don't have an advance directive, if you don't have a living will, or you don't have a healthcare surrogate designation, your proxy is going to be able to make all these decisions, all these healthcare related decisions for you. If you have a healthcare surrogate, you may provide that surrogate with all these powers in writing, or you can abrogate them, you can change them, you can take away some powers or add some powers, and these documents become malleable to suit your wishes, to make sure that the person that you decide that you want to be able to make healthcare decisions can do only what you want them to be able to do. Okay, so again, the ability to provide informed consent, refusal of consent, or withdrawal of consent to provide all sorts of medical procedures, including life-prolonging procedures, unless otherwise stated. The definition of a healthcare decision also includes the ability to apply for government benefits, for example, applying for Medicaid. Okay, access health information that the healthcare surrogate might need to make the decisions and apply for other government benefits, and make an anatomical gift. So this is really important. Let me back up for 1 second. The ability to apply for government decisions is embedded within the statute. Even if you don't have a healthcare surrogate, a proxy is who steps in by statute. There's an order. I have another video that talks about there's an order. The statute says here are the people who the state of Florida, give preference to if you, the person who's unable to communicate decisions and don't have the ability to understand what's going on, have not already provided for in a healthcare surrogate. So the proxy is like the default settings, okay? And if you have only relying on a proxy and you have no other assets and very little income, the proxy can apply for government benefits on your behalf. That's really important because it can help for those who need to apply for Medicaid, which is a lot of what we do in our office. It allows us to make that application, provided that there's no other planning that needs to be done if there's not an adequate power of attorney or a healthcare surrogate designation. Okay, so that's the broad definition of a healthcare decision. Very, very important. Let's move on. Okay, so now I want to talk about when your healthcare surrogate gets to start making decisions for you. And the answer is, first and foremost, regardless of who you have designated to make healthcare decisions for you, as long as you are cognizant, you are capable of intelligently communicating your preferences, the doctors are always going to listen to you and you only. It doesn't matter who you've designated in your healthcare surrogate. The issue is if your capacity is questionable, and if a doctor believes you don't have a medically reasonable probability of recovering that capacity, then they're going to consult with your healthcare surrogate. And the idea is that if the doctor can indicate that if your treating physician clearly can clearly indicate in your medical record that you don't have the ability to make decisions, they don't need to get a second opinion. They can immediately call upon the healthcare surrogate and let them know that they have to let the primary care physician know, and they have to let the healthcare surrogate know that now their services are needed. Okay? If capacity is questionable, then they'll bring in a consulting physician to do their own independent assessment. All that has to be very well documented in your medical record. Okay? So now let's compare and contrast that with a living will. A living will is an advance directive that only applies if you do not have the ability to make decisions for yourself. There's no reasonable likelihood of you regaining capacity, and you have either a terminal illness, an end-stage condition, or in a persistent vegetative state. That's it. One of those three conditions. This is the default. Again, you can kind of design this however you want, but this is kind of what the default looks like in a living will. End-stage condition, terminal condition, or persistent vegetative state. Now, if you have one of those conditions, the doctor is now not allowed to act alone. Now the doctor has to get a second opinion. Okay, and this has to be well documented. If the second opinion agrees that you have one of these three conditions, now it depends on what your living will says. A lot of people have a living will that says, if I'm in one of these conditions, end stage, terminal, persistent vegetative state, and there's no reasonable likelihood of me coming out of this condition with any measurable quality of life, then keep me out of pain, keep me hydrated, and let me go. Don't take extraordinary efforts to keep me alive, because it's sort of everyone agrees it's not worth it. But what'll happen first, if you have a healthcare surrogate or a proxy, is the doctor has to notify the healthcare surrogate, because you as the healthcare surrogate get to consent to the withdrawal, not you, the person you designated as healthcare surrogate or proxy needs to consent to the withdrawal of these life-prolonging procedures. Now what happens is, if the doctor says, here's what we're planning on doing, and your healthcare surrogate, your proxy disagrees, they will have 7 days from the doctor letting them know that they intend to withhold life prolonging procedures to seek expedited judicial intervention. They go to court. And if they go to court, the doctor's not allowed to withhold the life prolonging procedures until the court has made a decision, and there's an expedited process for that. If there is no living will, then if there is no healthcare surrogate, there's a different process that has to go through, but that's the subject for another video. But suffice it to say, it's really important. These documents are often glossed over by Floridians and estate planning attorneys alike as these are like the throw-in documents. They're really incredibly important for you to read and make sure that what you want to happen actually happens, that you're empowering the right people to make these life-critical, really important decisions that can literally mean life or death. And you want to make sure you have the right people who are going to adhere to your wishes, not their wishes. So I hope this gives you a little bit of insight as to the important interplay between a healthcare surrogate and living will, and how the definition of a medical decision making, and how important these things are to whether you're not able to make decisions for yourself, whether you're near the end of your life, whether you need government benefits such as Medicaid, and these are not to be glossed over. Thank you very much for watching.